everybody. People are coming in.
Hello.
Nice to see everyone. It's going to take a second. We still have some more people coming in. That's great. So great. We have 53, 55 people. It's good to see everybody. Still people coming in. Still a little jammed up here.
Right.
Okay, great to see everybody. It's happy Friday, happy summer. Thanks for taking a half hour away from the beach. I hope you all make it there this weekend. It's a beautiful hot day, roasting out there a little bit. So I hope you can make it to the beach, to the pool, or you go old school and open up that, as long as you have the safety cap on, the fire hydrant. Remember back in the day, kids went under the fire hydrant. I'm not advising you to do that, but back in the day, there was that cap thing that would turn the fire hydrant into the sprinkler. Anyway, I think that might be illegal now, so don't take my advice on that. Sorry. So nice to see everybody. Sorry for the delay in getting out the agenda, and also sorry for not dealing with the state constitutional law stuff versus the federal constitutional law stuff. I have gotten sucked into a few hot cases, and I'm having a little difficulty escaping them. So I'm doing some discovery stuff, just doing some New Jersey regulation stuff on fire code, et cetera, that I have to deal with immediately. So thanks for your patience today, and thanks for joining us. So the usual announcements are in effect, right? These webinars are provided for general informational purposes only. They don't constitute legal advice or create an attorney-client privilege or an attorney-client relationship. The information is exchanged is for educational purposes only. Again, to get legal advice, you have to go hire a lawyer, whether it's us or somebody else, and sign an attorney fee agreement. The information is discussed will not be kept confidential. So again, as I say every time, don't tell me about your trouble with your spouse. We cannot help you with that. So we do have a dog of the day today. Dog of the day. Eileen, we did dog of the day. We did. So
Emmy.
Oh, this is Emmy, owned by Marcos Jimenez, and Marcos rescued this dog. So rescue dog, beautiful rescue dog, and not the exact same name, but the name Emmy was inspired by Marcos's favorite grandmother, Emma. So there's a little trivia there for naming the dog. But a beautiful dog. Thanks, Marcos. And then we have a special one today. Let's see. So this is not a dog of the day. I hope you can see this. So,
Not yet. Yep.
So this is
There
you go. So that's Madeline Sturm, who is the board president at Four Seasons at Brandon Farms. And the reason I'm putting this up, she sent this to me because Madeline has never missed a First Friday with Fran. Never missed a First Friday with Fran. And so she had sent me that message saying, "Hey, Fran, I'm away in Texas with my family, and I'm going to be missing First Friday with Fran today." So Madeline is forgiven for that, but we do appreciate Madeline sending me a note saying she's not going to make it today, but she will be around next month. So I hope Madeline's having fun in Texas. So we are talking about collections today, which is a huge issue because none of us really knows where this economy is going, but we can tell you that there has been a slight uptick in association collections. And what we're seeing is more cases coming in, number one, and more cases, oddly, coming in with a higher balance, right? So the first topic we talk about is have a process and start early. Well, when we say start early is don't wait till the balance is $2,000 before it's turned over to us, right? You want to process, and in most associations, it's management letter, follow-up management letter, lawyer letter, right? So it's management letter, first lawyer letter. So usually that gets you out probably only about 80 days delinquent, right? When they don't respond to the first management letter, they don't respond to the second management letter, and then they're turned over to the attorney. So you are usually less than 80 days delinquent at that point. And that's why, for those of you who work with us, you know this, that if we get the account within 80 to 90 days of delinquency, the collection letter is free because we are trying to encourage our clients to start the process earlier. The earlier you can start the process, generally speaking, the more collectible the debt is. You see what I'm saying? So if it's much easier to collect the debt or get somebody into a payment plan when it's $900 rather than $3,000 or, God forbid, $9,000, right? So the sooner that you can get it in our hands, the better. And that's why we try to give an incentive there that if it gets into our hands, the collection letter, if it's within 90 days delinquent, the collection letter is free. We're trying to incentivize people to turn those accounts over so we get them cleaned up early. So that's have a process, right? So management letter, legal letter. Fair Debt Collection Practices Act. Everyone talks about the Fair Debt Collection Practices Act. It is a huge problem because you have to be very careful. It's essentially a strict liability statute for attorneys who collect sums on behalf of associations. So that's why we are very careful in making sure the debtor balance is accurate. That's why we do not collect interest, right? Even though many association documents specify interest. And the reason for that is many management software packages do not calculate interest properly. So we don't get into a situation where we try and collect it and wind up in a class action over the Fair Debt Collection Practices Act. That's also why it's very important for all of you to have authority to do what you do in your governing documents. So if you're assessing late fees, you must have a provision in your governing documents that support the assessment of late fees. You also can't put late fees on if your provisions say interest and there's no provision for late fees. So some people say, Fran, interest, late fee, they're the same thing. No, they're not. And what judges say to us is, Fran, if you're going to calculate interest is about a continuing balance. Like I said, we don't do it anyway, so it's never an issue. But late fees, judges will say, Fran, late fees are for late payments. So you can't tack on a late fee month after month after month if your unit owner only missed a payment in January, for example. You see what I'm saying? So let's assume they missed a payment in January. February, they paid on time. March, April, May, June, July, they all paid on time. They can't have a whole bunch of late fees on there. There's only one late fee. And what a lot of management software packages do is they will apply the February payment to the January outstanding balance, and it'll keep hitting as though February was late, March, April, May is late. That is not correct, right? From a software standpoint, that may be correct. I don't do software programming, but when we get in front of a judge, the judge is not going to allow us to collect those compounded late fees when the person has been paying. More importantly, under the Fair Debt Collection Practices Act, there may be a violation that gets us, the law firm, sued, and if there's a possibility that the management company could be sued as well. So that's the Fair Debt Collection Practices Act. Settlement agreements. We love settlement agreements. Settlement agreements are wonderful. We are not just crazy, bloodthirsty lawyers. We are not. We want your homeowners to pay in a timely manner. We have plenty of work, thank God. We don't have to try to jack people around unnecessarily to get them to pay their bills. So we strongly encourage our association clients to get into a settlement agreement if the settlement agreement is reasonable, right? So we want settlement agreements. Settlement agreements are great. It saves you attorney fees. It saves your unit owner's attorney fees, your homeowner's attorney fees, and it saves everyone a whole bunch of time. However, we like to use the 3-strike rule. The 3-strike rule is generally that if you're in a settlement agreement and you breach it, and then you're in a settlement agreement again and you breach it, and then you're in a settlement agreement again and you breach it, then the association shouldn't be talking about settlement agreements with you anymore and should say, we are proceeding. You're making us into a chumpy, right? It's the Charlie Brown and Lucy thing. You know, settlement agreement, I put the football in front of you and you go to kick it and we pulled it away. And then I said, no, I'm not going to pull the football away this time. And Charlie Van tries to kick it and she pulls it away again. And then the third time she says, no, really, this is no true this time. I'm really, God bless me, I'm going to do it. And she pulls the football away again. there will be debtors out there who do settlement agreements forever and ever and ever if the board allows it, right? And they will agree to it, breach it, agree to it, breach it, agree to it, breach it. So you have to be careful about that and pay attention, because in some people, especially professional debtors, it's just a game. They're just stringing you along and buying time. Let's see, moving on to the suspension of membership
Hey,
rights.
Frank, can I make a quick comment?
Yeah, go ahead.
About the settlement agreements?
Sure.
Just want to make sure everybody understands that settlement agreements, when you are entered into them, you basically are pressing the pause button on your collection actions, right? So you're going to collect money. If they default on their settlement agreement, you shouldn't be starting again at the beginning of the process. Rather, you should be picking up from where you left off and moving ahead. So oftentimes we find that if we've gotten to the point of getting to sheriff's sale and we have a sale scheduled, that's a really strong incentive for somebody to propose a payment plan, enter into a payment plan, and continue to pay, because if they miss a payment, they will ultimately just lose their home, because the sale itself is just continually adjourned while they're making payments. So just make sure that you're not starting at the beginning, because then, like Fran said, you'll be going down this road forever.
Right. Thanks, Mike. So while you're at it, Mike, why don't you say a few words on suspension of membership rights voting in Radburn?
Yeah, so there's just a distinction everybody needs to be made aware of between being current for suspending rights and privileges versus being current and voting and being eligible to run for the board. So under the Radburn law and the DCA regulations, you are a member in good standing if you're either current with your assessments, or you're in a payment plan, or you are challenging your balance through ADR or in the court system. Under all of those circumstances, that individual is current, or at least they are in good standing, and they can run for the board as a candidate and they can vote. However, when it comes to restricting access to amenities, taking away their pool privileges, not allowing them access to the clubhouse, perhaps towing their vehicle, it's a different standard. The standard is you are current with your assessments, period, right? Good standing in that realm is actually being in good standing and not having a balance. I do suggest to boards that if somebody's in a payment plan, you consider allowing them to access the amenities. Certainly don't tow their vehicle. And by the way, brief side note on towing vehicles. Communities can oftentimes do that for, we're talking about towing somebody who's delinquent, taking away their right to park in a common element parking area, but it doesn't extend to private property. So if a person has a deeded parking space in a high rise or mid rise, you cannot tow from there. If it's a townhome association or a single family home association where they own from the four corners of their lots and they have driveways, you can't tow from a driveway. However, if it's a condo association and the driveway is a common or limited common element, oftentimes the association has to pass a resolution and you have to comply with the Predatory Towing Prevention Act and put those 3 foot by 3 foot signs at all the entrances. You can oftentimes go through the process and then have a right to tow those vehicles. And truthfully, nothing is more effective, as far as I can tell, outside of suing and taking their bank accounts and wages. Nothing is more effective than towing somebody's vehicle to get them to pay. But anyway, just understand the distinction between good standing for taking away access to amenities versus their right to vote and run for the board as a candidate.
Okay, thanks, Mike. So just to add to one thing that many people don't realize from Radburn with respect to Mike was saying is 30 days prior to your election, you must send a letter to delinquent homeowners giving them the opportunity to cure so that they're able to vote, right? So it's you have to send them a notice of lack of good standing, which indicates why they're not in good standing and that they have a right to cure and or participate in ADR. So make sure that letter goes out. Mike, you want to say a few words about collection agencies?
Yep. Recently, I sat in on a presentation from a collection agency that does some association work, just to get a sense as to what they would be willing to do. And the long and short of it is collection agencies are not law firms, but what they'll do is they'll send collection letters to try to collect a balance. And that sounds easy enough. And they sell on how cheap it will ultimately be for an association. But if you peel back a layer or two, it ends up being, well, as far as I could tell, the most expensive way to try to collect. You know, this particular one I sat in on, I had asked them if, you know, there was a balance of $1,000 owed from a debtor, you know, what is their fee? And they kind of kicked around the answer for a bit. And then finally, the answer was $400. So that's $400 for the collection letter, which is a really expensive collection letter. And what you see happen, at least this is what we see for communities that try to go down that road in the idea, the thought of trying to save money, those debtors that are going to be a challenge in the long run, you know, professional debtors, those that are not willing to just write a check right off the bat, they will get pushed to the wayside and nothing happens on those files. So what you'll see happen is their balances will continue to grow month over month. And eventually it'll get pulled from the collection agency and it'll get turned over to the law firm for collections. And like Fran had mentioned at the get-go, their balance is no longer 2 or 3 months in arrears. Now it's 2 or 3 years in arrears, and it's much more difficult to collect. Now we have to go through the whole process of suing them, obtaining a judgment, looking for assets, levying, garnishing wages, bank accounts, possibly foreclosing. It's a much more arduous, expensive process than it would have otherwise been had we started with a low balance. But you know, there are a couple companies out there in the state that are pushing community association work. You just have to be really careful about the costs that are incurred, the long-term cost and then the short-term cost to the debtors.
Right, thanks, Mike. So one of the other, just to add what Mike said, what we've run into also with one collection agency is they've taken the position, even though they're not buying the debt, if you will, that they can hire their own lawyers, strangely enough, and they're not the association lawyers collecting the debt. So it's been very strange. So for example, I had one client that came to me and said, hey, Fran, somebody filed a lien for our association and we never hired this attorney. And I had to reach out to the attorney and I said, what are you doing? And they said, oh, I work for this collection agency. I was like, well, I know, but show me your fee letter with the association. He goes, we don't work for the association. We work for this collection agency. So it was very strange. So if you're going to dip your toe in the collection agency world, as Mike said, be very cautious.
And Fran, one final point on that. So
Yeah.
once a file is removed from the collection agency and turned over to counsel to try to collect the money by taking wages and whatnot, their claim is that they are now entitled to a percentage of every dollar that's collected going forward. And again, going back to the actual cost to the association for doing that, it can get really expensive.
Yeah. So Mike, want to say a few words about credit reporting agencies?
Yeah, well, I mean, we were talking about this earlier. So we don't report to credit agencies. In fact, the collection agency that the presentation I sat in on, they typically do not do so either, simply because that opens up a world of problems for the community association as well as the collection agency or law firm, where if we do not have the actual dollar calculated properly, presented to the collection agency, we, the association, law firms can get jammed up under the Fair Debt Collection Practices Act, the collection agency, what's it called? The
Fair Credit Reporting Act.
Yeah, Fair Credit Reporting Act. So the long and short of it is that we do not go down that road.
Yeah. Let's see. So liens, people understand, right? And some people do, some people don't. Liens are like mortgages. Liens are like mortgages. Liens become a property interest in the home, right? Which is a little bit different, a lot different, if you will, from a personal debt. A lien, like a mortgage, attaches to the property itself. And so people say, oh my gosh, Mary Jane filed bankruptcy, filed Chapter 7 bankruptcy. She's going to wipe out all of her debt. That's not true. That's not true. If you file a Chapter 7 bankruptcy, a no asset bankruptcy, they would call it a no asset bankruptcy, but that does not wipe out the liens on the property or the mortgage on the property. As many of you have been on this webcast before, is they survive. Otherwise, all of us would run out right now and file Chapter 7 bankruptcy to wipe out the mortgages on our homes, right? We would. It would be a beautiful thing. We could all just walk away from our car loans and our mortgages because those types of things, if not for the fact that they're secured by liens, people would do that, right? So you can't have a mortgage, you can't have a lien, and you can't have a secured car loan and walk away from it and keep the collateral, keep the property, keep the car, keep the house. So what happens is many times when we get a new association client and we talk to them about, say they have 10, 20, whatever collection accounts open, and we'll say, what's happening with these accounts? What's been going on with them? And they'll say, well, we're going to write off these 4 or 5 accounts because the person filed bankruptcy. And we say, wait a second, do you have liens? Did you file liens? And they say, no, we don't file liens. And we'll say, okay, listen, here's the deal. You're not going to be able to collect that money now because you never filed liens. But if you had filed a lien in these cases, you would have gotten paid. So it's crucial to file liens, especially if there is any risk whatsoever of a bankruptcy filing. And if you do have liens filed, God bless you, that's awesome. Make sure you don't just knee-jerk write off an account because someone files Chapter 7 bankruptcy. Liens pass through bankruptcy, okay? In a Chapter 7 bankruptcy, the lien passes through, remains attached to the home. In a Chapter 13 bankruptcy, it either passes through or is paid off in the plan itself. So Chapter 13 has a plan for repayment, usually over 5 years, 60 months. And a Chapter 7 bankruptcy is a liquidation. So it blows out all those unsecured claims like credit card debt, medical bills, etc. But it does not discharge your liens in the property. So please keep that in mind. I see many associations writing off significant amount of debt that is secured by liens on the home when in fact they could be paid the lien amount. Now I'm going to share screen for a second, and some of you have seen this chart before, some of you haven't.
Hey, Frank, can I just make a quick comment about
sure, go ahead.
the liens? So
Sure.
just a couple other reasons why you put them on. One, it secures the debt owed against the property. So the person cannot refinance now or sell it to somebody else that's going to take out a mortgage, so that you would have to get paid at closing on either a refinance or a sale. And also, if an association files a lien prior to a bank initiating a foreclosure, the association would be entitled to a 6-month lien priority, which means that at the bank's sheriff sale, they wipe out other secured claims against the unit, except for taxes. And now this 6-month lien priority, so you would ultimately receive 6 months worth of assessments due to the association from the purchaser at a sheriff's sale or from the bank. And by the way, you can update those liens annually. And if we put multiple liens on before a bank starts to foreclose, you would get 6 months lien priority on each individual lien that's on there.
Yep. Thanks, Mike. Okay, so I'm now going to share the screen again. Some of you have seen this flow chart that we've created. Some of you haven't. It's a little bit busy, but we'll kind of talk our way through it quickly. We're at 12:30 now, so we'll try to talk our way through it here. You see that? Can you see this? Okay. So this is a flow chart where, so we have the liens, and people ask us, what is a money judgment and what is a foreclosure action? So a money judgment is on the left in orange. Foreclosure action is on the right in blue. The basic difference between the two of them is in a money judgment action, you are pursuing the personal debt, right, of the person. So you're pursuing the person, getting a judgment against them and trying to grab their assets, whether it's bank accounts, wage execution, getting a portion of their wages, etc. In the foreclosure action, totally different action. Seems similar, but totally different action. You're pursuing the property. So like I said, in a foreclosure action, just like a mortgage foreclosure, you are foreclosing on the lien that the association filed, right? And eventually taking the house back, right? And you say, that's crazy, Fran McGovern. Can you do that? Yes, you can, and you should. And if they want to pay off, they can, but otherwise they're going to have to leave the house and leave the community. Does the association have to pay the mortgage if there's a senior mortgage on the property? No, but the mortgage lien stays on the property and eventually the mortgage company will foreclose, right? So then people say, well, Fran, why would we foreclose? We can't flip it and make $1 million on the house. Why would we foreclose? Most times, especially in a market like this one, if you file a foreclosure action, the people will pay off the debt. Why is that? Because most people, as opposed to 2008, most people today have equity in their homes. Real estate, even though it has plateaued somewhat, real estate values have gone up significantly since 2008, and most people have equity in their homes. So they would be foolish to let the association foreclose on the home and risk losing their equity. So most people today would enter into a payment plan, a settlement agreement, or what have you. On the money judgment side over here, as Mike said, we do things like levy on wages, levy on bank accounts, levy on rents. So if it's an investor-owned unit, we can levy on the rents, levy on other personal assets, etc. So the money judgment action and the foreclosure action are two very good tools for collecting association assessments, and that's the core of our collection practice. God forbid there is a downturn, a serious downturn in our economy right now, we can help. We can help. We did a great job. I'll pat myself on the back. Mike can pat himself on the back. But we did a great job with many of our association in the 2008, 9, and 10 era, collecting assessments when they were very, very difficult to collect. We had to get creative. Some of you are on the call today. We got into things like rent receivers. We got into things like taking title to units and renting them. At one point, I saw somebody. I thought I saw Joe Schultz. At one point, Joe Schultz.
Yeah, Joe's on it.
Yeah, at one point, Joe Schultz Association. We had about 14 or 15 association units that we were renting out. Right, we're renting out on a monthly basis for quite a long period of time, and the association recovered a lot of money with respect to that. So if the economy does continue to dip and we see it continue to see an increase in association delinquencies, we will get into things like rent receivers, levy on rent, and things like that, and possibly even associations owning units. We have one, and I think that some of the board members are on from this community too. We have one association that still owns a unit that we foreclose on and still continues to rent it probably 5, 6 years later now, maybe even more, 6, 7, 8 years later. So that's kind of the association collection world in a nutshell. I wanted to highlight that. I was going to get into something else today. Like I said, I haven't done enough homework, honestly, to give you the overview on the distinction between federal constitutional issues and state constitutional issues, even though that's a hot topic. That will be coming up probably September, October. To be fair to all of you who spend your time on this call, I want to make sure I'm properly prepared for that, and I just really wasn't. But the thing is, I wanted to go to collections because we are seeing an uptick, and we are seeing some association boards reluctant to turn things into the collection process, and the cases that are coming in have, in my view at least, significant balances when I think we could have dealt with them more quickly and not let the association kind of get behind the 8 ball with some of these accounts. So it's good that we are seeing the real estate market flatten out. Not it's good that we see the real estate market flatten out, but it's good that we highlight the collection issue right now so that as the real estate market plateaus, that you are all on guard for the delinquency issue. All right, I think we had one chat question. Fran, can we get a copy? Can we get a copy of the chart? Yes, we can send you a copy of the chart. The only one, let's see, the only one we can't send it to is, I think I saw Ben Lambert on the call too. No, we co-counsel with Ben Lambert, who's a great guy and a very smart attorney. So Ben, even if we'll send the chart out to everyone. If legal fees are added to an account and the homeowner is paying the current month's fee on time, can late fees be added to the legal fees? So that's a good question, Jeff. I generally would not. Jeff is saying, hey, if the person was a delinquent, but a delinquent account, and we started to accrue attorney fees against it, but they're paying the regular monthly fee, can we add late fees? I think the answer to that is no, and I think most judges would agree with that. Judges would say, Fran, if you want to charge something for a continuing balance, whether it's legal fees or something else, it's got to be interest. It can't be late if they're paying on time. Um, Eileen says, can you find out the amount of the mortgage on the property? Another good question, Eileen. That's great. Generally speaking, no, we can't find out the mortgage balance. And that's because mortgage companies will not tell you the balance as of today. However, with a title search, we can generally find out what the original mortgage balance is and when the mortgage was taken out. So if a mortgage was $100,000 and it was taken out in 1990, you can anticipate that it's probably been paid down significantly. But you can also, when we do our title searches, we can also find out if there are judgments outstanding, tax liens outstanding, U.S. Employment tax liens outstanding, things like that. So we can get a rough estimate if the association is looking at taking and keeping a unit, whether it's worthwhile from that perspective. So a lot of property managers, you know, they're savvy as to the communities that they work in. They know generally, roughly, what the fair market value is of the homes we're talking about. And they can say, hey, friend, you know, homes generally sell here between $500,000 and $600,000. And we do our title search and we find that there's only $200,000 in liens apparent on the home. We know that will be a good association home to pursue and possibly either pursue to take and hold or pursue to flip. But again, that high mortgage balances should not discourage the association from pursuing foreclosure. Because at the end of the day, if you have a homeowner who is not paying, you want that homeowner out, period.
Fran, I have a question here.
Yeah, go ahead.
From Terry, she says, what balance amount is a good benchmark for filing a money judgment? So Terry, I think the question really is like starts with at what point should it get turned over to the attorney's office for collection? And I think it depends on the community. So if you have a regular community charging $200 or $300 a month, typically you would want to turn it over before they're 3 months in arrears, 2.5 to 3 months in arrears. And this way you can initiate collections right away. If they pay quarterly, you know, $100 a quarter, some communities wait significantly longer than 2 or 3 months. Oftentimes, if they are low balances, like a community that only assesses quarterly, $150 a quarter or so, we will send a collection letter, put a lien on, and then perhaps sit on that for a while until the balance accrues to the point where now it makes sense to file a money judgment. But it's really a judgment call depending on the amount of assessments and type of community.
Right. So the next question, I think I missed it, was can we run credit reports on people? So that's a very tough question in terms of a maybe, right? So there's the Fair Credit Reporting Act, which generally provides the regulations for who can run credit reports, whether they need permission, et cetera. So that's one issue. And the answer as I sit here is I don't know, but the Fair Credit Reporting Act would govern who can actually run them. The problem is if you're talking about running a credit reporting act with respect to a potential homeowner, I have never seen an association, whether it's a condominium association or a homeowners association, attempt to stop someone from purchasing into a community based on a credit reporting, a credit report. So I think I would have to say that that's very dangerous grounds right now. Definitely talk to me or talk to your own association attorney before doing anything like that. I will put the caveat out there because we work with a number of co-ops. In co-ops, that's very commonplace. In co-ops, it's commonplace for associations to do things like credit reports and screen people out based on credit reports, because in a cooperative form of living, you're not really buying real property, you're buying into a corporation. And the corporation is permitted to inquire as to whether you have the wherewithal to be a shareholder in the corporation. So it's very different in the co-op world. I have not seen it in the homeowners association or condominium world. You want to take the next one, Mike?
Sure. Next question says, what would a reasonable interest rate be after a first late fee for delinquency? Well, I mean, I can tell you in New Jersey, the usury interest rate max is 18% a year or 1.5% per month. But like we said earlier, our office will not seek to collect those interest rates. We don't suggest putting them on. because it gets really hairy with the Fair Debt Collections Practices Act and actually collecting the appropriate dollar and penny on each account. So we do not suggest doing that. Rather, what usually makes more sense and is a lot cleaner are placing late fees on their accounts if they're not making their payments on time. So interest would be the continual running balance, just like your credit card, versus not making the monthly payment on time, which would be a late fee. And again, we would not suggest charging interest for continuing running balances.
Okay. Let's see. I think that was the last question. So I guess we'll let you all get back to the beach or your site inspections on Friday afternoon. I hope everyone has a
Angela's
great
laughing.
weekend. I hope everyone has a great weekend. And thank you so much for attending. I will see you next month. Thanks again.